Good morning. The case which I am going to refer would facilitate you to acquire knowledge how to deal with civil cases pertaining to the deposit with bank, immovable properties, partitions, and how suits are being filed restraining the bank authorities from disbursing. All this would be easy for you to understand, and the ratio in the judgment AR 2023 Madras 306, AR 2023 Madras 306, acting Chief Justice S. Vaidyanathan and R. Kalaimati held that earlier suit for partition in respect of immovable property of deceased was disposed. Subsequent suit filed for partition in respect of fixed deposit made in various bank and financial institutions. Subsequent suit is not barred by Order 2, Rule 2. They have held this. Daughters are entitled for 1/6 share. So it is very easy to understand this case. The three daughters seems to have filed a suit for preliminary degree partition. Schedule amounts to 1/6 share. The degree was passed, so they filed appeal. Appeal was disposed by acting Chief Justice. The objection was by under Order 2, Rule 2 CPC and Pacific Relief Act. The subsequent suit is barred by principle of res judicata. The courts held that for this only I want to refer the judgment. The first suit was filed. For an order of injunction to restrain the defendants from paying the deposit amount with accrued interest to the nominees. So that suit was filed. Then again, so the relayed judgment of Parvati versus Valliammal. Another suit was filed restraining from paying the amounts to the nominees. Yet another suit was also filed for an order of injunction restraining the defendant from paying the deposit. So this way suits are being filed. So you be very alert to file suits. For injunctions, you need not pay court fees, ad valorem. Partition suit, you have to pay the fixed slab under section, I think that is 6 of the Tamil Nadu Court fees and suit variation. Kindly go through the judgment. This will help you. What is Order 2, Rule 2, principle of res judicata, and Specific Relief Act prohibition of subsequent suits. That area should also be concentrated if you go through the entirety of the judgment. Then you must understand, in this case, AR 2005 Supreme Court 29 was also followed. I hope you understand. Sometimes what happens when I read some judgments, I am hurriedly communicating to you. Therefore, there may be some practical problem of explaining the entirety. But how could I explain the entirety of boring other young advocates who only concentrate on criminal side and other areas, not willing to step in civil proceedings. Therefore, by just placing some ratios and the cause of action facts, I am leaving it to those advocates. So that this communication may not be bored. Only that reason I am not fully discussing, except when the case must be discussed deeply. If so many concept of procedure and substantial are being discussed in the subject. Best wishes.